Industry government, industry government. I think one for tribal, okay, two for your content.
I'm for the respondent, my lordship.
The writ petition has been dismissed.
Deeply obliged, my lordship.
Right.
Two, your 49 or 25.
I'm appearing for the petition, Your Lordship. The affidavit of service has already been filed. Yesterday, the respondents did not appear. Even today, they are not appearing.
What is the matter about?
Your Lordship, the issue here is with regard to appointment of commissioner under Order 3927.
And you were directed by the learned trial court for an investigation. Order 39.
Your Lordship, the learned trial court has assessed that the questions that we intended to frame for the commissioner to ascertain, that could only be assessed by the civil engineer. That is what is the observation of the learned trial court. Whereas our application was under Order 3927, not under Order 26. And the questions may be looked into, Your Lordship. What were the questions that we intended? Your Lordship, page number 26 of the petition. Page number 26.
26.
Page number 26.
That the water is oozing from the roof of the rented premises. What is the present position of the roof of the kitchen? Present position of the doors of various rooms of the soup premises with a painting that is required to be carried out.
For these questions, Your Lordship, whether there is a requirement of civil engineer. That was the observation, and our application under Order 3927 was rejected, Your Lordship.
Impugn order is order dated 3rd July.
3rd July 2020.
Hmm. Petitioner is represented. You had filed an affidavit of service yesterday, na?
Your Lordship.
Affidavit of affidavit of service filed in court be taken on record. So the Mr. Aran appears on behalf of the opposite party despite service. Yes, the instant revisional application has been filed sealing an order dated July 3, 2025, passed in other suit number 21 of 2024. Rejecting the prayer of the petitioner for a local inspection in terms of the provisions of Order 39 Rule 7 of the Code of Civil Procedure. Next one, the submission on the this petition filed in the other suit was directed to obtain the present position of the property involved in the suit for the purpose of repairing. Okay. Stop this. You were the plaintiff. The petitioners were plaintiff slash tenant. Tenant in respect of the premises. Stop the defendants slash opposite party were the landlord of the properties. And what is the stage of the proceeding at this moment?
It is fixed for written statement.
Written statement has not yet been filed. So the plaintiff is filed the other suit number 21 of 2024 before the next civil judge, Junior Division, First Court at Port Blair. Have you arranged the plain you have annexed?
Plain is an exception. Page number 14.
14 years. The suit was for declaration of the declaration of tenancy rights of the plaintiff slash petitioners together with other ancillary reliefs. Page number 14. 14 is
14 is the plain here. Page number 14.
it is informed that the landlord slash defendant is yet to file his written statement in the said suit. Stop here. And what was this petition? Order 39, Rule 4?
Order 39, Rule 4, that the one was seeking repair. That application is still pending.
That is still pending.
That is still pending. We sought for appointment of commissioner before this application. So this application was filed along with the application for appointment of
That was for the repairing work.
For the repairing.
Repairing work. Stop here. Next paragraph, the plaintiff slash petitioner in the said suit filed an application under Order 39 Rule 7 of the Code of Civil Procedure seeking appointment of an advocate commissioner to ascertain the present physical position, physical status of the premises, uh, namely, 26 intact report for the 826. 143. Next paragraph. The defendant had filed any written objection against this petition.
Your Lordship.
So
We have filed the written
the
objection.
landlord's right defendant filed an objection to the petition under Order 39/7 of the Code of Civil Procedure filed in behalf of the tenant.
Page number 40.
40.
41. We have admitted para 16 may be seen, Your Lordship, page number 43. Page number 43, para 16.
They have admitted that you are a tenant.
The tenancy is not in dispute as of now.
The
because
contract
they are
for
not filed
denied and that
written
the plaintiff himself in his position. Police service to my report, my statement for them in a very dangerous position. Yes, admitted to the extent that the tenant actually stop in such a written objection, the landlord defendant admitted that the plaintiff tenant was a tenant in respect of the suit premises underneath. He, however, objected to the appointment of an advocate commissioner for the purpose of ascertaining the present physical status of the parties, status of the suit property. According to the case made out by the petitioner slash plaintiff, the premises under his occupation, the tenanted premises under his occupation has gone dilapidated and requires immediate repairing.
Dilapidated may not be used. Is in such a position
Has gone in such a position that an immediate repair was required. Stop this. Learned trial court considered the application filed on behalf of the petitioner slash plaintiff and the defendant slash opposite party, and by the impugned order rejected the petition under Order 39/7 of the Code of Civil Procedure filed by the petitioner slash tenant. Observe premises which rendered the premises inhabitable. Uh, Inhabitable.
Difficult for the parent to state. Harshit, because inhabitable word
That will be taken.
aliens land.
Rendered the building. Rendered it difficult for the plaintiff/tenant to inhabit in such premises. Yeah. Two and three, what was the two and three? Slowly, Islamic trial court, while disposing of such application, in respect of point number small Roman 2, that is IA, what is the present position of the roof of the kitchen, and small Roman 3, what is the present position of the doors of various rooms of the suit premises, comma, opine, comma, in the impugn order, that such questions can be looked into by a civil engineer. So an advocate commissioner cannot ascertain the position as required by the aforesaid points of ascertainment. Stopping. I have mentioned. I have already held hearing before that the petition under order 39(7) of the Code of Civil Procedure was directed to ascertain whether water was seeping from the roof of the tenant premises, and whether it required any repairing repairing for better habitation of the plaintiffs therein. No construction work was sought to be undertaken in the said premises. Which was to be ascertained by a civil engineer. So the petitioner under reference was directed only to ascertain whether any repairing was actually required for a smooth habitation in these two premises. So, next paragraph is circumstances. The impugn order under number 8 dated July 3, 2025, passed in other suit number 21 of 2024 is is set aside. Should I allow it or left to be allowed by the trial court? Because appointment has to be made by that court only.
That appointment will be done by the trial court, but as the objection is also here, this one can allow the second application as well. Because this court has gone into the application.
So in the next paragraph, trial court shall proceed to appoint an advocate commissioner as commissioner for the purpose is mentioned in the petition under order 39 rule 7 of the code of civil procedure filed by the petitioner slash plaintiffs on. You filed it on
1st October 2024.
filed on October 1, 2024. That's all. CO such and such is accordingly disposed.
Double 327 of the 21.
My lord, I am for the applicant number 1, 2, and 3. Sorry, respondent number 1, 2, and 3. my lord.
Respondent number 1, 2, and 3.
I am appearing for the petitioner, Your Lordship.
You were directed to
Exact. ये भी है लगता है ना.
respondent
1, 2, 3, and 4. my lord.
Service has been effected, Your Lordship. The period of service has been filed. On all the respondents, service has been.
affidavit of service delivered. Five. You are for 1, 2, and
1, 2, 4. my lord.
1 to 4
Yes.
and 5. What do you want to do? Huh?
Your Lordship, I will read that I have two representations which I have submitted before the respondent authorities. Primarily, it is the duty of the respondent authority that is in question here. So I pray that the representation be disposed of in accordance with law. That is my primary claim. What has happened, Your Lordship? There was one Street Vendors Act introduced in 2014.
And what is the position of private respondent?
The private respondent herein is actually, she is sitting in the shop of the petitioner, which was allotted to the petitioner by the respondent authority. And this shop was allotted under a scheme, that is the street vendor scheme, that was introduced by the respondent authorities. In 2014, one Street Vendors Act came in. After that, in 2015, the Union Territory herein has formulated a rules. That rule came in 2015. Then a scheme was formulated in 2016. As per the scheme, the street vendors were given a certificate of license to operate specific shops. The petitioner herein was also given a license to operate a particular shop, and she operated in that particular shop in terms of the license. In the year 2021, she got injured, and for her treatment, she went to mainland. She kept two people as caretaker to take care on her behalf, and she kept on paying them the required money which they paid to respondent authorities on her behalf, and the license was getting renewed. What has happened when she returned from mainland, she found that these people are not vacating. Therefore, she approached the respondent authority. The respondent authorities have power to evict any unauthorized person who is operating in that particular shop without license. And thereafter, she submitted two representations. That is to renew her license, and secondly, to evict the unauthorized licensed person there in accordance with law. And that representation is still pending.
Not so far as there.
And who are you?
I am the person who was actually given the license to operate that particular shop. And I had operated there. I was paying all the dues as well.
Then respondent number 5. You are saying
That respondent number 5 was a caretaker. During my
Lord, this
absence,
was their
when I went
contention
for
was that
treatment,
they have been given with a vending license to run a particular shop. But
the petitioners.
petitioner. But in the shop, already they say that we have allowed some persons to be as a caretaker, but he was running the shop. Now he is occupying the shop and he don't want to vacate the shop. So this is what their contention. My lord, the rules which has been relaying, it shows that there is also a grievances of redressal dispute was also there. And if any order passed by the vending committee, then it should be an appealable order also. It is prescribed under the rules.
my lordship,
Lord,
rules are very clear. If there is someone who is without any license operating in that particular shop, that the respondent authorities have the duty to act. Let them find out, let my representation be disposed of. Let them find out whether what is the actual situation. If they find that that person is operating with particular license, let my application be disposed of in that manner. My representation.
Lord, this is a youth.
Because the respondent authorities are admitting that the person who has occupied my shop, that person is not operating with the license.
Not operating with the license.
Not operating with the license. Your Lordship, I would like to raise
Lord,
that
so
there
far
is
as we have not given any reply or any to that extent that he was without dancing, but we only say that he also not allow anybody to run the shop which was given to him, because as per the vending act, it is given to him. He cannot give it to any third person also. But he says now at stand that it was a caretaker and he is occupied. So that has to be, that is a
have not
disputed fact.
transferred it.
my
I
lord.
cannot transfer it because it is not in my
You
name.
cannot transfer it,
I cannot transfer it.
but the person who is presently holding that property, how did he come in?
When he has approached my lord, first he has come in 19 June 2025. When he has got the license to operate. 2021.
And I was operating continuously.
So where is the document that he was operating
The
continuously?
dues have been paid to the municipal council.
No document to that extent has been enclosed. Certificate of vending was issued in 2nd August 2021.
That was valid till 1st August 2023.
That means
I have also applied for renewal of the certificate. They are not allowing me. Your Lordship, the petitioner is a 65-year-old lady, Your Lordship. She does not have knowledge of online application and all those procedures, and they are not even accepting offline payment. They are asking a 65-year-old lady to come and do the method in the manner of an online payment. And she approached. She has already submitted a representation. She took assistance from the council herein. She approached the authorities and an application for renewal of license was also submitted, and that is still
When?
pending. Let them decide. Let them
when
dispose
it
of
is
it.
submitted.
Your Lord.
My lord, these so
You-
far as the annexure is
You say
concerned.
that
Page
you
number
have not,
85.
you have not received any application for renewal.
My lord, so far as my lord, as face of a record, page number 82 is a certificate of vending. If my lord will see, it was a date of issue was on 2nd August 2021. Validity of certificate is from 2nd August 2021 to 1st August 2023. He could have, if his renewal should be prior to 1st August 2023.
2023.
If he could have come with the renewal, it should be 1st August 2023. The second aspect is that, my lord, he is saying that page number 83, that is a representation which come after a period of, I suppose, not at the, it should be 2 years, my lord, 19 June 2025.
Your Lordship, there is no
19 June 2025.
There is no such representation.
Renewal is cannot be
For
sued
renewal.
to renewal. It has to
Let them
become.
dispose of my representation. Let them
Why-
dispose of
why?
it.
Certificate of vending was till 1st of August 2023.
23.
Then
No, no.
how can you say that there was no limitation?
Even that was till 2023. Even after that, they allowed all the street vendors to decide.
That is a
They were
not a
taking
matter over here.
The other municipal dues were
Negative,
being taken from me.
negative equality
Yes,
cannot be
yes, yes.
claimed.
Your Lordship, I understand, Your Lordship.
Then?
What I am saying is,
Did
I
you
have a-
apply, did you apply
Prior to this,
within 1st of August 2023? Where is that application?
Your Lordship, that is in page number 85, Your Lordship.
85 is 19 June 2025.
85 is 19 June 2025.
Your Lordship, herein I have specifically mentioned the reason for me not applying within the time period. Let them dispose of.
No, DRIT code cannot be adjudicated in this manner
I am not
because
asking the court to adjudicate.
they have to show the bona fide requirement. They have to show the bona fideness.
Your
When the
Lordship,
bona
but if
fideness
their
is
own
lacking,
lady,
they
can she be
merely
expected?
they want it should be condoned by way of consideration of this representation.
not
They want to
saying
condone the
that-
period of delay. That cannot be permitted.
Not asking for any condonation, Your Lordship. They have not yet rejected my application.
They have to show the reason why they have not filed the renewal
And
prior to
fifteen
1st August
percent,
2023.
What have you done with their
No, the representation is 19 June.
Ah.
Now we are in August 19 June 2025.
disposed of?
This representation has not been disposed of.
Lordship.
But so far as the concern is there, Lord, he says that he has to be considered as a legitimate vendor. That part goes when he has not submitted the renewal. Automatically, the vending part of August 2023, that is over.
Whatever.
If he could have shown any document prior to 1st August 2023,
Your Lordship.
in accordance with the law.
Saying that they are not entitled.
Yes.
That you can say.
I have two representations, Your Lordship. One is for renewal and one is for eviction as well. That is another
Eviction?
representation.
Eviction, you will have to go to civil court.
Your Lordship, I'm not asking eviction on the basis of I'm not declaring my position here. I am just asking the respondent authorities to act in accordance with law. That is
Who are-
because
Who are you to
Your Lordship,
decide?
because the shop is till today, it is in my name. Till
My
today, as
lord,
per the record, it is
that-
in my name.
My
Let
lord,
them
already
show-
one
let-
first-
Let them show a document
How can you
that
say that?
No, this is from the certificate of vending. It is
Your
supposed.
Your license expired with 1st of
Your
August
Lordship,
2023.
because the person who is at present in the possession of the shop, that person is paying all the dues in my name, and that person is
And
taking
they are
money from
accepting
me.
that.
That
And they
person-
are accepting that.
they are admitting that
That
person is
doesn't-
in possession.
That doesn't mean.
Your Lordship, that representation may be also disposed of, Your Lordship. Let them say. Let them say that they cannot, but there has to be a disposal of that representation as well. Because the rules
Understand.
specifically provide, Your Lordship.
Uh,
When I have been given a license and someone else is operating in the name of my license,
that you can settle it in the civil court.
Your Lordship, that is not my own property, Your Lordship. That is
not your property, but your name is being used for running that business, that shop room.
Your Lordship, let them dispose of this representation. If at all in merit if it comes, then I can approach the civil court.
Registered rate application has been filed seeking a direction upon the official respondents, being respondent number 1 to 4, to consider the representation filed by the petitioner for renewal of license and also for eviction of the caretaker. Could be. Case of the petitioner that that the petitioner was allotted is a shop room situated at two Boston vegetable market under Andaman and Nicobar Island street vendors bracket protection of livelihood and regulation of street vending. that we closed. Scheme 2016. On August 2, 2021. So the vending license was issued in the name of the writ petitioner, which was valid 80,
85 or I'm sorry.
no, 82,
82.
valid between
1st August 2020.
2nd August 2021 to August 1, 2023. Stop deal. Stop deals in terms of such vending license issued by the authorities, the petitioner have been selling vegetables from the allotted slot. Stop deal. It is further stated on behalf on behalf of the petitioner that some that she had to go back to the mainland due to certain medical condition in the month of September 2021. Stop the in her absence, she appointed. And who are these persons? Santosh and Surabhi
It's point number 5.
and Surabhi.
Surabhi is his wife.
She has not. Two people in her absence, but she appointed respondent number 5 to be caretaker of her business. So the rate petitioner returned in 2022 and approached respondent number 5 to quit and vacate the slot allotted in her name. So the said caretaker went on purchasing time and ultimately he refused. And ultimately he refused to vacate the premises of the petitioner in okay, the petition full stop. So it is also submitted by the petitioner that the aforesaid caretaker is still paying taxes for the allotted slot in the name of the petitioner. So next paragraph. In the meantime, the validity of the license issued in the name of the petitioner expired with a flux of time, which was valid till August 1, 2023. Stop here. The petitioner applied for renewal till August 1, 2023. So the petitioner applied for renewal of her license on
19/6/2025.
huh?
19/6/2025.
On June 19, 2025. And also for
Seek apology to entrepreneurship. It is specifically mentioned that from the time of expiry, I have been repeatedly approaching the authorities, but because in my representation, that my submission may be recorded in that sense. But because I was illiterate, I could not understand
I
the
oppose
form.
this.
Submission.
license in June 2025 and also
for a removal of the caretaker. So the Bernard advocate for the petitioner also submits that before applying for a renewal of her license, the petitioner has been approaching the authorities on several occasions.
Which I denied, bro.
That is his submission
I'm sorry.
for renewal of her license. So the the learned advocate for the petitioner submits that till date the representation of the petitioner has not been considered by the authorities. Next paragraph further. On the other hand, learned advocate for the official respondents number 1 to 4 submitted that the petitioner never approached before the authorities for renewal of the license of our license. So it is also submitted that the license issued in favor of the petitioner has was expired with August 1, 2023. By a flux of time. So the however, when I advocate for the petitioner could not apprise the court as to the result of the representation submitted on behalf of the petitioner. So the next paragraph. Having considered the submissions made on behalf of the parties and also considering the matters placed before me. So the is admitted position that the petitioner was issued with a license, vending license, which was valid
1st August 2020.
On 2nd of August, valid between August 2, 2021 and August 1, 2023. Stop the according to the according to learned advocate for the party for the respondent or the opposite party.
Respondent, because official respondent.
Read petition. Respondent. The license issued in favor of the petitioner has already expired with August 1, 2023 by the flux of time. Of the learned advocate for the petitioner has claimed that a representation for seeking renewal of license has been pending with the authorities, which was filed by the petitioner on June 19, 2025. Next paragraph for the petitioner learned advocate for the respondent authorities could not explain during the hearing that such representation dated June 19, 2025 has been been considered by the authorities. Struck the next paragraph. In such circumstances, the writ petition is disposed of with the direction from respondent number 1 to 4 to consider the representation filed by the petitioner on June 19, 2025 in accordance with law.
There are two representations, sir.
The representations. Data baki.
And after providing an opportunity of hearing.
Stop. No doubt. In considering the representation filed by the petitioners, the authorities will be at liberty to provide the petitioner an opportunity of being heard. Stop here.
Lord, the writ petitioner and the private respondent also be mentioned.
The authorities will hear such other parties and consider such documents as it deems fit. In consideration of the representations. Recorded people of the region.
Not down.
The authorities are also directed to communicate the result of their decision to the petitioners and the parties they heard within fortnight from the date of the decision. We will communicate it
Within fortnight.
within a fortnight of the decision.
The proceeding has to be concluded, not there is any time.
That you consider. W2, certain is
Obligatory.
disposal.
Like, you know.
Now, 55, 125.
I was waiting for the respondent because
Which for the petitioner,
Mr. Prakash Lynch is appearing.
none appears for the parties. None appears on behalf of the petitioner. Respondent, on sole respondent.
No, Lordship. Two respondents are there.
And you are representing both.
Yes, Lordship.
Respondents are represented. This is the matter. Last day you were also not present.
Lordship, I was appearing through video conferencing before court number 1.
Okay, I have recorded none appears on behalf of-
I was appearing before court number. I meant that with this court also called my name.
tomorrow.
Lordship.
They will come. If you can get hold of the other learner.
I will try my level best.
That's all.
Okay, 5, 3, 6, 7, 125.
Lord, this is a, I raise the point of mentability. Lord, why I say so? Because
Being on behalf of the senior, I may request for a short pass.
Pass over.
This is the course number 1.
Lord, they want a proceeding which is initiated under 133 CRPC. But that proceeding has
Oh, that one.
that, and they have to conclude. They want it should be concluded within certain time limit. But writ petition is not maintainable, but they have to come with civil criminal revision.
Revision.
Criminal revision.
Because
Writ cannot be
rate cannot be maintained.
because in the 132
Uh,
specifically it is mentioned.
Come back on tomorrow. But with priority. First, second court, then first court. Not today.
P, 3, 6 of 125.
Not these items 6, 7, 8, 9, 10.
6, 7, 8, 9, 10.
10. These are with connected to.
Madam, tomorrow. And just see, is writ amenable, judicial order is amenable to writ
Yes,
jurisdiction?
Lord, I am not seeking any substantial order with regard to noise pollution. I am seeking the final, the completion of the proceeding which has been initiated by the subdivisional magistrate.
Then
That I am seeking.
And,
The additional order was
that subdivisional magistrate for the purpose of this is a judicial authority. At
Yes.
least quasi judicial authority.
This honorable court has found the order directing.
So,
Yes, Your Lordship.
once committed error, always
No, it's
committed.
not an error, Your Lordship. Because the subdivision magistrate
Come
has
back,
got-
come on.
I will come back.
Come on.
Under
Six,
the section 133, Your Lordship, he has got the power to do it. This is a nuisance which is created here.
no, not saying that.
6, 7, 8, 9, 10.
133 criminal revision will like this.
That
I'm
is
asking for completion, I'm not
That is
asking for.
completion against in 133 proceedings.
completion of a proceeding.
133 pages.
Why will the division? That petition is maintainable. I'm asking for completion of it. I'm not challenging that order.
They want a proceeding which is under 133, which is under CRP.
As if a direction against the tribunal to dispose of the matter as early as possible. That is.
Rate is not material.
I am not asking for a specific relief with regard to the merits of the order. I'm asking completion of the proceeding. Yes.
Tomorrow,
Tomorrow.
but with priority.
Yes.
And 6, 7, 8, 9, 10.
But this is a matter which I received the copy just now. But a similar matter was when an order was entertained by this honorable courts in court number 1. But we checked the records, but just not today.
Not today.
Not today. I checked the
Or
records.
it can be released and placed before the, because that honorable court has already passed everything. I would be seeking the same entry relief. Or this honorable court also can pass that same order. It depends upon your lordship. I'm comfortable in it.
Petition
I cannot-
Let me not today, but I checked whether that is the impugn order in all the
Yes,
matters.
You just see this.
No, no, I have appeared in this matter. That's why I want to know the records. I check the peruse the records and I will appear.
Yes, yes.
Not today. No. ये करके approximately मध्य 6 to 10. 6 to 10.
Yes, ma'am.
Then it's 345. I'm appealing for one of the opposite.
You are for the opposite party.
Not for all, I'm just giving opposite party number 7.
And who is for the petitioner?
I'm appealing for the petition, Your Lordship.
Yes, sir. CEO. What is the order under challenge?
Your Lordship, there are 2 orders under challenge. Your Lordship. First order is related, both are related to service of summons, Your Lordship.
The fact of the that to fresh upon respondent number 1 positively by on the date fixed. TCS will comply. For taking steps by appellant afresh upon respondent number 1.
Your Lordship, what has happened before the first appellate court, all the respondents have been served apart from respondent number 1. When the appellant tried for service upon the respondent number 1 through ordinary way, as under order 5. The service came returned. In the summons report, it was mentioned that the particular respondent has gone out for work and she will be coming. As to when she will be returning, it is unknown. She has gone out for work. And how the process server ascertained that? Upon asking from a person who is residing in the neighborhood. That was that. When the summons report came in such a manner, the appellant again filed a summon through the way of speed post. The said summon was served to the respondent number 1. The tracking report mentions that the item has been delivered to the HSC. That was placed before the learned first appellate court. Despite that, the learned first appellate court did not consider it as a good service.
And asked for a fresh service.
After that, as that was also not considered as good service, the only option left was for publication in the newspaper. Under Order 5 Rule 21, the appellant therein filed that application. What the learned first appellate court observed that court has observed that that application is premature and has kept that in abeyance and has asked me to again file summons to ordinary. When the item has been delivered to the addressee and the respondent number one has received the item, that is a valid service. I can read this provision from order 5, Your Worship. So
That is
has to be
there,
considered.
but
That
there
cannot
was
be
an order
overlooked.
of the court. And who is not appearing?
The same respondent is not appearing here.
And have you served?
I have served through Speed Force.
Where is this?
I believe affidavit of service has to be filed. It has not been filed yet. I'll file it. By tomorrow, I'll file it.
Let it be on tomorrow. Not today. No, it actually put it. So, petitioner and some of the respondents are represented. So be it is submitted on behalf of the advocate for the petitioner, that respondent number one.
Respondent number one.
This is CEO, it will be opposite party number one. Opposite party number one, you have to be served. Could be, no, has been served, but affidavit of service.
Your Worship, that has to be ascertained. So
Oh.
let this be not today, just not today, Your Worship. That tomorrow I can ascertain.
List the matter tomorrow. I'll give choice. 6. Oh.
Thank you.
Appeal, number 202/2025.
Item number 12.
This is pending quite long period of time, nobody is appearing. Time for some of the respondent, my lord.
Petitioner, respondent number 1 and respondent number.
Yes, my lord, so
5.
this is
Good.
that matter, my lordship, wherein the petitioner is since last 2 days not also appearing. So we made a submission,
Last
so
3 days.
specific chance has been given today to appear.
Due to some personal matter.
So since he is not interested, my lordship, let it be dismissed. And
You are for?
official respondent.
I'm also for one of the respondents.
Then appears for the petitioner. So on the official respondents and respondent number, you are for?
Then record. Order chief लगाया.
Huh?
Rakesh Kumar is.
You are for respondent number 2 to 5
Yes, my lordship.
and respondent number 1. Respondent number 2 to 5 and respondent number 1 are represented. So the next one is appears from the record that will appeared on behalf of the petitioner on July 28, 2025, July 30, 2025, July 31, 2025. Stop there.
What chance would the
Next paragraph is the circumstances. The petition being business for default. Business for default.
Oblige, my lordship.
This was all.
Item 13, my lord. It breaks just not today because not it is an affirmation stage. The appeal and opposition will be filed tomorrow.
Affidavit in opposition.
Yes.
Then,
Case accommodation we got it tomorrow. it will be filed.
For filing the affidavit.
Yes, day after tomorrow it may come, my lord. I'll serve the copy of affidavit.
You have not been served. On the prayer made on behalf of learned on learned advocate for the petitioner. No. I'm responding. This is the matter on 8 or 7. 7th. Petitioner is represented.
14, 2 and 4 must be defined.
14. But I'm for the respondents. Bro. Petition.
I'm playing for the petition here. The authorities, where to submit a report reduction.
Some of the documents communicated with the order, then needs to file a report. Compliance of the. You have filed the report.
No, my lord, I seek extension of time to file the report, not till next Sunday.
Petitioner and respondents are represented. So on the prayer made on behalf of an advocate for the respondent and to file the report in the form of an affidavit.
Yes.
In the form of an as directed by order dated July 28, 2025. Order dated July 28, 2025 is extended for the period of 1 week.
Yes.
Let them file then, list the matter before the next available judge. Nothing to be done. He has been able to get through.
No, my lord. Apply.
Oblige, Your Lord.
Yes.
15, 17, 0 must be defined.
It's the matter, I paid the petition.
You are for the petitioner.
I am appearing for the response.
It's applied for the electricity connection.
Opposition,
In month of January.
opposition. Affidavit in opposition.
Lordship, my affidavit is not ready. That is.
For past 3 days.
Yes, yes,
It was
yes, yes.
seeking.
Yeah, last time, that is the recording.
Before that also there was an.
Yes, yes, I am admitting, but my learned senior is making some.
Extend, you'll not extend the electricity.
I am praying for extension of time.
That I will extend, but you will not extend the.
Lordship, they have to bring the no objection from the Tehsildar because they are the encroacher of government revenue lands.
It is
So
not necessary.
that is my
Not
point.
necessary, Your Lordship. On the last occasion, Your Lordship will see when the bench also they have passed the order. I can bring those orders also. So basically, because the petitioner, he gives an undertaking that as and when I am required to vacate the premises, I will vacate. Upon relying that affidavit only, they are giving us electricity connection.
When will you file your affidavit?
But it will take some time. If weeks or 10 days
Can
time.
you see this order?
If this order is passed, I don't have any objection.
The petitioner says in circle position was relevant for the application shall be considered in accordance with the law. If this order be passed,
Yes, Lordship. If petitioner is agreeable.
In accordance with law.
has to be in accordance with law.
That is a second.
Then you have no objection.
With that.
You have no objection.
Yes.
And what is the document of your position? Have you annexed something?
Yes.
With respect that
Voter ID card fees, I think, page number 40.
14.
40, Lordship.
40. 40. And the address is C19 Neil Island.
Yes.
Now it's become 33.
Huh?
Earlier it was Neil Island.
That doesn't make any difference. Then that order, dispose of with, huh? Disposed.
The 16, that was C4C of 125.
I am appearing for the respondent, Lordship. This petitioner is already having a connection, Lordship. I have the report. May I place, Lordship?
Yes. Petition that,
Point number 1.
and what is the prayer, sir?
For grant of electricity.
Electricity connection. In reference to the above.
the same
rules,
premises, he is seeking another
that,
connection.
The following point, existing connections is already an existing consumer of.
Yeah, the matter here is the electric connection which is given, which they have mentioned, is of the husband. And husband and the lady used to reside in a government quarter at that moment of time.
Sir, your Srimati Kurdulla means
Yes.
she is a consumer, recorded consumer. That is the report.
Correct. Here. As per the instruction, what I got from my.
You want to, you are filing this, no?
I am submitting for this honor. Let him take the exception.
Yeah, you can take exception to this report.
May I get back this report? I will place before the court officer. I will hand over a copy to him so that it will be better for him.
नेता दिए थे
Within 10 minutes, I am submitting it Lordship, because I have matters in.
I can record this. Should I record this?
Let it be recorded.
Let me write book for the respondent undertakes to file a report in course of the day with a copy served upon learned advocate for the petitioner. Stop the learned advocate for the petitioner seeks to take an exception to such a report. When will you file the exception, sir? Any day means tomorrow. Next para in such circumstances. But I have already recorded that you will file it in course of the day.
Lordship, let it be tomorrow, Lordship. Let it be tomorrow because it has to be affirmed by the authority concerned. I am handing over a copy, Lordship. Let him take the exceptions to that.
I am fixing this matter tomorrow.
Lordship, I will provide the copy to him. If he is
On the prayer made on behalf of the respondent, leave the matter. Tomorrow is 6.
Lordship.
Then they will.
In the meantime, I will serve the copy. Lordship.
I appear for the petitioner.
Lordship, this today morning only I have received the writ petition, Lordship, from the department. So can it be day after tomorrow or tomorrow, Lordship? Because
You are
this
for the
belongs to Neil Island.
You are for the respondent.
Lordship.
On the prayer made on behalf of the advocate for the petition, for the respondent, list the matter on 7th.
Obliged, Lordship.
The petitioner is represented.
Number 260 of 19. Not the response I have given.
And therefore, it could be some of the respondent were to be served at the first instance. Lawyers appeared, lawyers vanished. Then I have been directed by this court to serve it. But see, the address of that private respondent 456 are at Calcutta. Are at Kerala. Last known official address. Now they have shifted the office. I have brought back the envelope with this endorsement. So I'll come up with order file rule 21 application last known question, but it will take time. So let it come in.
On the prayer made on behalf of for the petitioner, list the matter before the next available circuit, to uh, enable him to take steps for service upon respondent number 4, 5, and 6 in terms of order dated July 30, 2025. So you are for the petitioner.
And the respondent,
The
respondent.
Oh, Takala Purota, I'm responding to the petitioner. Respondent is represented. Official respondents.
One of the.
Next available circuit.
Yes.
Lordship, one slight mistake I have committed, Lordship. Because similar, another one matter is taken for court number 1. Being WP number 344. Here the WP number is 343. But I have the same report.
For both the
Both the separate report is there. In both the house, in both the houses connection is there.
Just give him a copy, file the report. Tomorrow we will pass the order.
Okay.
You might be, city one of the report.
Your Madam.
Mr. Shivapala is dodging the issue.
It is his personal, it is his personal, he is in code number 1, my lordship.
All the submission makes no sense. Paperwork is ready. Book has been given to him.
I will
want
pray
to get a
for,
paper, my lord.
For
he informed me that to request for next circuit, my lordship. It's not a,
that is why he was dodging.
no, nothing. The initial,
I understand.
On the prayer made, petitioner and respondent are represented. So on the prayer made on behalf of learned advocate. You are for the respondent.
Leonard Foxy VD Shivavaran, it is his personal private dispute.
Ma'am, you are representing the respondent.
Yes, ma'am, Leonard Foxy.
Learned, for the respondent. List the matter before the next available circuit. You will feel the heat before the next available circuit. Uh, From tomorrow, I will not be listing any hearing matters.
Yes, sir.
It will be difficult then to deliver them.
My senior appeals for the private school.
But I'm referring for the official response. But the petitioner has filed a supplementary affidavit during the course of the hearing, so we have given granted time to file reply to the supplementary affidavit. So, my lord, we seek an extension for filing.
It was first time extended on 29th of July.
Yeah.
Before,
Yes,
before me.
Yes, yes.
Then it will also go beyond the circuit.
Lord, these difficulties we have to prepare.
Petitioner and the respondents are represented. So on the prayer made on behalf of the lead advocate for the respondent, official respondent.
Yes, sir.
Official
As well as the private.
You are for the
Private respondent, my sister is appearing.
I'm noting your submissions. Official respondents, time to file affidavit in reply. You will also file affidavit in reply is extended for 2 weeks, 1 week.
1 week only.
For 1 week. And then 1 week and you will file any reply. Oh, affidavit. List the matter before the next session.
Obligation.
Private respondent is also represented at the line of the court.
Item 21, WA-254/2024.
You're for the respondent. Petitioner? Petition. Petition of who is for the petitioner?
I'm there.
Oh, you are.
They take time also because several number of
An
litigations.
exception to the report. Today they have found the exception to the report that was filed in 20.
Affidavit filing report. You are filing.
I have taken out an exception to the report they filed in the form of affidavit.
Exception to the report, no, to the report. In the form of affidavit is filed in court with on the court.
And see the copies.
So the copy served. From the next paragraph on the grave and the petitioner is the matter before the next available circuit.
Item 22.
Next available.
41/2025.
And for the petitioner, my lordship, in this instance, you. Here, my lordship, I am challenging the order dated 25/4/2015,
25.
4/2025, my lordship, sorry. Passed by London Joint Civil Judge Senior Division, which is at page number 63, my lord.
24th of January,
25/4/2025, my lordship, which is at page number 64, my lordship,
64.
64. Here, my application, my lordship, under 151 of the CPC was rejected. As well as I filed some summons, my lordship, issuance upon some pocket witnesses. That was also returned to me. What happened, my lordship? This is a suit.
And why didn't you take a steps?
Sorry, my lordship.
Why didn't you take a steps in time? Why didn't you examine the witnesses?
My lordship.
When it was fixed for defense witness?
I will come, my lordship. I will come. What happened, my lordship? This is my lordship, very long pending matter, my lordship. Filed way back in the 2008-9 sometime. And when the suit was filed, my lordship, at that time, this defendant, he appeared, my lordship. This is a suit between landlord and tenant. So this defendant appeared, and on 26/2/2014, my lordship, when the WS was filed, at that time, the entire payment has been made to this petitioner, the respondent herein, by the petitioner. Believing that, my lordship, the case is already, since at the time of filing of WS, the payment has been made through check, and in the WS there is averment, my lord. Specific averment is there. We made the payment in respect of the tenanted premises.
What is the reason you did not adduce DW?
I'm coming, my lord. What happened, my lordship? This petitioner, my lordship, since January 2024 to till 24/1/2025, my lordship, she was suffering from some, my lordship, loss of taste, and this issue was there. So that's why she went to Tamil Nadu.
Where is the petition? Under section 151?
It is. I'm coming, my lordship. It is P2, my lordship.
Which?
I'm coming, my lordship. One minute, my lordship. I'm coming. At page number 34, my lordship.
34.
Yes, my lordship. Here, my lordship, para 3 is the important one. That the defendant got very good case in his, in her and there is good chance for the defendant to win the case. But the order dated 24/1/2025 can be recalled and the defendant may be given a chance to adduce the evidence on behalf of defendant her case. Here, my lordship, on 24/1/2025, the evidence was closed. So on 10/4/2025, I filed this application 151 for recall of that order so that I can adduce the evidence. And on 25/4/2025, my lordship, this application was came for hearing and in page number, which is in page number 64, my lordship. Wherein, my lordship, my intention is very clear. On that day, this defendant was present. Even I filed my examination in chief, my lordship may kindly come for some of the pages which is very relevant, my lordship. Page number 67. Here I want to adduce the secretary in this Kala Parishad, the plaintiff, the different respondents. So I filed this summon. Thereafter, I also for page number 69, my lordship.
That is accompanied with your petition.
Yes, my lord. I filed, so my intention was very clear to adduce. But prior to that, my
What is your
lordship.
justification in not adducing evidence?
Yes, my lordship, that.
When the case was fixed for.
Yes, very nice statement, my lordship. This respondent, petitioner, my lordship, she was in Chennai, my lordship, taking treatment for loss of taste, all those
And
things.
where have you-
There was a digestion problem also there.
And
For that,
and where have you pleaded that in your petition?
in my lordship, in the CO, it is pleaded, my lordship.
Just one sentence that.
Yes, my lordship. In CO, it is pleaded, my lordship. In the petition, I have stated due to her illness, he is not able to appear. That was there.
That cannot be accepted.
But my lordship, the thing is that when she was, I have annexed the flight
She
ticket
was,
also, my lordship.
she was all along watching the proceeding.
No, my lordship.
To buy time.
She was in mainland, my lordship. I have annexed the flight ticket also. In order to show my lordship during that
Did
period.
you place that flight ticket before the trial court?
No, my lordship. That,
Was it an
my lordship, that time my lordship, she was not present here. So return ticket was submitted before this court, my lordship. I have stated before the court that she is out of station.
It took time to arrange the ticket.
No, my lordship. She was actually in mainland. And thereafter, when she came back.
What was she doing at mainland?
My lordship, she was undergoing treatment, my lordship, for past 1.5 years. Because there is a digestion.
Did you place the treatment document?
My lordship, there is a difficulty. She undergone some homemade document medicine, my lordship. Because these are the problems that they cannot approach the medical. So she went to her village, Samayapuram, at Trichy, and she was doing treatment there.
What is this suit about?
This is a suit for my lordship.
Tenancy.
Yes.
Tenancy and landlord.
Yes, my lordship.
That is
And-
the usual way of buying time.
My lordship, kindly appreciate, my lord. This case was filed. It's a long pending matter, my lordship.
I am not concerned with the long pendency
Yeah,
of.
and they have taken ample.
You were given sample opportunities to adduce evidence. You could not explain for the non-production of your witnesses, non-examination of your
But
witnesses.
my lordship, continuously,
And the learned court rightly refused.
no, my
Clear?
lordship, because my lordship, there is a good chance of success, my lordship. If opportunity has been given, my lordship, within 2 days, I will finish my evidence because this dependent has to be examined.
You talk to your opponents. If they
Definitely they
agree,
will not ready, my lord.
if they agree, then only.
Because it will take my, I will totally, I will adduce 4 witnesses, my lordship. The first one is the dependent. There are some corporate, I will issue summon, my lordship.
You are a tenant
Yes, my lordship.
and
But thing is that my lordship already,
what will you do with 4 witnesses?
Landlord is not receiving the rent.
my lordship, one bank official is there
Bank official will
to
prove
bring,
what?
to show that they are denying that I made the payment. So I will bring that bank witnesses with the statement.
You are paying with the bank.
Yes, so what happened, my lordship, when I filed the WS, at that time I paid the entire check amount.
That chapter is
So
already over.
in order to prove that thing, my lordship, I need to adduce that witness, that bank official.
Bank
Because they
official
are
will
denying.
prove what?
In order to prove that, my lordship, when the suit was filed,
Huh?
we paid, and there is and we assume this
Paid
dependent,
to whom?
this respondent only, my
Then
lordship.
what will
My lordship,
bank
to
of-
check. Because now, my lordship, they are denying that payment. That is the issue. They are saying that we have not received any payment.
I have objection to
It is their submission in the lower court.
the said fact that we are denying.
No, I am not deciding on that.
Your Lordship, I will be allowed to submit your motion. First of all, Your Lordship, this case has already proceeded ex parte, not first time, for the second time.
And it was fixed for ex parte argument.
Ex parte argument. And a case, when it is proceeded ex parte, that ex parte order has to be set aside, not has to be recalled under 151. They filed an application for recalling the ex parte order.
Decree has
No, evidence was closed, my lordship.
decree
I
has been
think,
passed.
no, my lordship, evidence was
Decree
closed.
is yet to be passed.
Decree is yet-
Yeah, order 9 rule 13.
Your Lordship, order 9 rule 7 ought to have been filed.
That was, my lordship, way back 2017, it was passed.
Yes. What has happened, Your
And that was
Lordship?
refused.
No, that was allowed.
Times.
Some 2000 payment has been, fine has been imposed, which I paid, my lord.
2016, I filed the suit. Till 2019, they did not file written statement. The case proceeded ex parte.
No, my lord. It is wrong submission, my lordship. 26 to 2014.
Keeping this matter tomorrow, in the meantime, if you can persuade your friends, after all, you have to fight out on the merits.
Yes, my lord.
So you just,
If
if you can persuade, otherwise, so sorry. Hey,
Let me try my luck.
Huh?
Let me
You
try
have
my
to
luck.
Fight out on merits, even if I dismiss this proceeding, it will add up to the proceedings after proceedings.
Your Lordship, I would like to consent with my client regarding
Yes.
cost
Yes,
in better.
that is
Problem.
what I am suggesting him.
Your Lordship.
If you can persuade your friends,
Yes, my lord. I will
That
try.
Since 2016, Your Lordship.
otherwise,
We are-
I am sorry.
My lordship, within 2 or 3 minutes, I can adduce the witness, and thereafter it can be decided on merits, because
How can
Hmm.
that will give,
it before the party, Your Lordship? Until unless order
because
16 rule
for
3.
that I can put. party नहीं है यहाँ. I participate.
Tomorrow or day after,
Day after tomorrow, my lord. So
And then
that
we-
I can get enough time to convince
to
them.
persuade them.
Right.
On the prayer made on behalf of the petitioner, is the matter of 7th, Calcutta,
Problem, my lord, sir.
Calcutta 6th, 7. You are for the petitioner.
Yes.
Petitioner and respondent is the matter on 4-8. Small matter.
Take time. All relates to land, authorities action and question here. I'll take time to file reply.
We have already filed our position, and they have received in the month of June.
June.
Month.
Affidavit in opposition filed by respondent number 2 within 2 weeks from get the plate any because
20th of June.
filed by respondent number 2. You are respondent number 2.
One for 112.
June 30th June.
Madam.
Prays for time to file affidavit in reply. Petitioner and respondent number 1, 2 and 3 are represented. Step P, next paragraph, on this they have met on behalf of learned advocate for the petitioner. Comma, time to file affidavit in reply is extended for a period of 10 days from date. This is the matter before the next level.
Blair.
I'll